So
how is it different than I've said?
It is, because you've also told me you're somehow appealing in the appellate court for me appointing an attorney, but now you just told me you want me to appoint an attorney to consult with. Which one is it that you want? Do you want an attorney to do not interrupt me? I hold you in contempt. I'm adding 20 days to your sentence. I've warned
Daddy
you twice.
pulled the car over.
Hi guys, it's Kathy. I hope you're doing well. So we got a contempt of court, but you have to see what leads up to that contempt of court. Is this guy pro se? Yeah, even the judge can't answer that at this point.
Or try to retain any other attorney?
I have family that's looking into these things. We haven't been able to. We're trying to negotiate with them.
Okay.
You know, it's difficult.
Okay. So far, so let me just put it this way. So far, you have not yet hired an attorney. Is that correct?
I'm trying to put my house deed up, and I've got it.
Okay.
I'm trying to do what I can to, you know, my brother passed away 2 weeks before I was put in here, and I haven't even been able to straighten out that matter. It's just, it hasn't been easy.
I understand. But it sounds like so far, while you're trying to potentially hire an attorney, at this moment in time, you have not yet hired one. That's a fair statement?
With an attorney, we've got to go all the way back to the preliminary examination and try to fix what was damaged there. Going forward, we're at a disadvantage because of what I feel was ineffective assistance. I feel I was entitled to a fair shot at the actual apple in the district court and didn't get it, and now I'm sitting here with this little bit of nothing.
Okay, so hold on, Mr. Burns, and I remember this got us off track last time where you wanted to argue about certain things, and I appreciate that you mind. Let's try to focus just on my questions first. So the question again was, have you retained an attorney? And so far you have not retained an attorney.
No, sir.
Have you spoken with anyone else, or has anyone else from the public defender's office spoken to you about them representing you?
I think someone tried to call here, and then they sent some investigator here named RJ or something, and he's not even an attorney. He came yesterday for a few minutes and left.
Okay, so let me.
So I haven't been able to consult with an attorney.
Hold on. Let me ask the next question. Do you wish to? Because I appointed another attorney last time. I said the public defender's office will represent you. And you filed something you entitled Notice of Appearance, saying that you wanted to represent yourself. Is that still true? You want to represent yourself?
I filed an application leave to appeal to Court of Appeals over it. Yes.
So the answer is yes or no, Mr. Burns, yes or no?
Yes.
All right, there we go. You told me that you haven't retained an attorney, and you told me that you wish to represent yourself and you don't want appointed counsel. Is that correct? You do not want me to appoint another counsel?
May I clarify? I mean, what I'm saying is I'm not going to establish a relationship that has to be separated if I can consult with an attorney about, you know, the things that I got in my mind. That would be fine. But I don't want to have to come back in and say, oh, I want to get rid of this lawyer because this, they're busy. I understand that, you know, they don't have time for this, and I haven't been able to consult with an attorney, and I don't want to establish a relationship that has to be severed by the court. Commitment issues. Forward, that I choose to go forward. I haven't been able to consult with an attorney, say, hey, this is what's bothering me. This is, to try to help me kind of marshal the facts, kind of, help me make sure that, I'm in the right vein, going in the right direction, on the right trajectory here. I feel that this is pretty much all pretrial motions. This is pretty much a case of
Mr. Burns, I'm not, hold on. This is very, very simple.
Yes.
In the last 3 weeks, I have allowed you the opportunity to either consult with a retained attorney, which you haven't gotten a retained attorney, and I have allowed you the opportunity to have appointed counsel. But you rejected the appointed counsel and filed your own appearance 2 or 3 days after that last court date. So all I want to know is, do you want?
Your Honor, I filed 4 or 5 motions that were sent back to me. So since the preliminary hearing, other than the ineffective assistance of counsel, I haven't been able to get on the record at all.
Hold on one moment.
And when you did appoint counsel, I just heard from him yesterday, and that was a couple weeks ago.
Hold on one moment, Mr.
Motions all this time.
Hold on, Mr. Burns. Yes, Madam Clerk.
The last time we were here on September 8th, I brought the motions up for that hearing.
Yes.
It was determined that Mr. Burns was going to have appointed counsel.
Yes.
And you instructed me to return those motions to Mr. Burns to discuss with his new appointed counsel.
Okay. The question was, do you want another attorney appointed to assist you? No, right, that's it. That's all I needed. That one answer was all I needed.
Your Honor,
so, yes, sir?
I was under the impression that I couldn't file anything. You sent it back to me. I had no reason to believe that I could file a motion after you ordered me to take appointed counsel, and appointed counsel never came up here to see me. So in either hand, I could not proceed forward. I went to the Court of Appeals. If we're going to get it on the record, let's get it straight. I don't have the impression that I'm free to file motions, and I don't want to file them and have them sent back to me if the clerk's not going to file them.
If you don't file them,
I asked you what day the motion day was, and I noticed all the motions. I would notice each one 7 days after the date of the nearest motion day. I know how to file a motion, and I know how to notice it. I wanted them to at least be received by the clerk so that in the event that we were going to go forward, I was going to, at some point, we got pretrial motions that haven't been done, and it was certainly not done in the district court. I've asked for a remand, or at least let's get their hearing going so that we can go back and start there. I feel that's the only way that we're going to be able to get the prejudice fixed that's already involved in the case.
Mr. Burns.
Yes.
Mr. Burns. But we have already addressed that because you told me you do not want counsel appointed. Is that correct?
Is this Taekwondo here or what? I've stated under the circumstances how that happened.
No. Do you?
I wanted to. If there was an attorney that I was able to consult with, I would have consulted with him. There has been no attorney for me to consult with other than Harrison, and Harrison wasn't consulting. He was doing whatever he was doing with the sniffles or whatever. No, I didn't have an attorney to consult.
Mr. Burns, stop talking. Pay attention. The question's very simple. And I've asked it.
The answer's very simple.
Stop talking, Mr. Burns. If you interrupt me one more time,
I will hold
you in contempt.
I will pull this car over.
If you were to ever get sentenced on this case, you will not get credit in that sentence for the time you're serving for contempt.
Yikes.
Do not talk when I'm talking. Now, the question I have for you is, do you want an attorney to assist you? Yes or no?
To assist me in what fashion?
Represent you in a criminal case in a criminal courtroom here in Wexford County.
As a lead counsel.
do you want counsel at all? You've said yes and no, back and forth.
No, I said if you have an assistant that can assist me in complying with the court rules, then because of what down at the jail here, I don't have all the access to the materials. If that's the case, fine.
Okay, that's different than what you've said. So
how is it different than what I've said?
It is, because you've also told me you're somehow appealing in the appellate court for me appointing an attorney, but now you just told me you want me to appoint an attorney to consult with. Which one is it that you want? Do you want an attorney to do not interrupt me? I hold you in contempt. I'm adding 20 days to your sentence. I've warned you
Daddy
twice.
pulled the car over.
Contempt. Finally, contempt. The judge had enough. Once judges are done, they're done. There's no undoing a judge that is done. He's done. I'm going to leave the link to the full hearing in the description if you want to see if we ever get to, do you want an attorney? Thanks for coming out, guys. I hope you have a great day. Bye.